rise. The Court of Appeals Division 1 is now in session.
Hi, thanks. Please be seated. All right, we're here for oral argument on our CV24 0086, Paulin et al., the City of Phoenix, and the 6th and Garfield owner. Each side has 20 minutes to argue. You're in charge of keeping your own time on that. We both live stream and record the oral argument, so when you stand up, if you'd please tell us your name and the name of your client before you get started. And just as a reminder, we conferenced this case this morning. We read the briefing, studied the record, and with that, please proceed.
Good morning, and thank you, Your Honors. John Riches. I'm joined by my colleague Timothy Sandifer on behalf of plaintiff appellants Matt Engelhorn and Bramley Paulin and their businesses. With court's permission, I'd like to reserve 3 minutes for rebuttal. The City of Phoenix has created a legal artifice whereby it has called a private high-rise luxury apartment building, quote, government property, so that it could subsidize one private developer to the tune of $7.3 million. This special treatment is afforded to some, but not to others, in the city's sole discretion. That violates both the text and the purpose of the gift clause, which prevents these sorts of arrangements, quote, by subsidy or otherwise. It also violates the evasion clause, which prevents these sort of transactions that are cloaked as artifices and says that those sorts of things are not exempt from taxation. If the trial court's decision is allowed to stand, it would not only hollow out the protections of both the gift clause and the evasion clause, but it would transform the affirmative defense of laches into a tool that is so easily invoked that it would either result in a rush to the courthouse by plaintiffs, or it would encourage government entities to engage in delay or gamesmanship so that they could avoid judicial review of their actions.
Mr. Richards, I want to start with laches because I think that is a pivotal point for us to decide. What is the standard of review that we should be looking at, in your opinion? How should we be looking at that?
It's the standard of review is de novo, Judge Foster. It's a question of law that this court reviews de novo. Any factual findings that the court made, and none of those are in dispute, would be subject to abuse of discretion.
So the trial court made substantial findings as to the reasonableness and made some findings as to prejudice. If it's an abuse of discretion, how do we get over those factual determinations?
Judge Foster, the court would weigh on its own the factual findings underlying it and conduct a de novo review with respect to both prejudice and reasonable delay. We think that's very clear from the case law. Importantly, too, laches is a doctrine in equity that is not encouraged. It's discouraged, and Arizona courts have made that clear for decades.
Can you tell me, because I noticed in the briefing that you said that the gift clause claim and the evasion claim are linked as far as laches is concerned, that nobody made an argument below that somehow there was a different analysis for one than another. And I think your briefing says that, and they say, okay, well, we have no problem with that. Is that, if that's true, are we looking at laches as, from your viewpoint, are we looking at laches from a, this is the transaction that we warned you we were going to litigate, or is there any case law that says we should look at these as different claims? Because the findings that were made below seem to focus solely on whether taxpayers raised an evasion clause claim and didn't really give credit for any of the correspondence that you had with Garfield and the city about gift clause.
Right.
And so are we to look at it as kind of a operative facts scenario or claim by claim? And tell me why.
Sure. It seems pretty clear to us that the trial court applied latches only to the evasion clause claim. The record makes that clear in the court's orders because it specifically cites, hey, look, they cited the gift clause when they were sending these letters to and from the city. It says that in the final order. Interestingly, it also says it in the order where the court denied the appellee's request for attorney fees. It again says this only applies to the evasion clause claim. The problem with the latches finding is it completely inverts the burden of proof here. The appellees have the burden to prove by a preponderance of evidence that latches applies. So they have to prove both prejudice and unreasonable delay. Prejudice, the only piece of evidence in the record, this is the only piece of evidence in the record, and it can be found at Appendix 336, is a declaration from the intervener's authorized representative that says, quote, Garfield would not have been able to mitigate any potential losses and potentially renegotiate the agreement with the city. What the latches case law says is they have to come forward with affirmative evidence that there is substantial harm. This sort of speculative potential harm that might occur is simply not sufficient under our latches case law. We also never had an opportunity to test that evidence, Your Honors. The motion to dismiss and the summary judgment motion were both decided on the same exact record. Interestingly, the trial court came to two separate conclusions there, but on the same exact record. But we never had an opportunity to depose the 30B6 witness. The only discovery we had was limited to the preliminary injunction stage.
Couldn't you have asked for that? I mean, he gets rid of the gift clause at the motion to dismiss, but he tells you to continue to brief the motion for summary judgment, which at that point is just evasion. So when you say we didn't have an opportunity for a 30B6, didn't you have an opportunity for a 30B6?
Well, at that point, Your Honor, the court had already denied in the motion to dismiss their latches defense.
Well, but
so
I'm not sure I read it exactly that way, and I'm not sure it's important because you still had a motion for summary judgment
Right.
where you had a 30B6 option, you had other remedies in the summary judgment rule to say we need to time out because we wanted to depose him. So I'm only questioning you
Sure.
on the fact that somehow it sounded like someone else took away your right to have a 30B6 on that.
I suppose my way to respond to that, Your Honor, is it was not clear to us that latches was still, after it was denied at the motion to dismiss stage, it was not clear to us that...
And I guess I just read the motion to dismiss as saying your gift clause claim is out. I mean, there wouldn't be, if they found that substantively the gift clause, I think he said if the transaction wasn't subject to the gift clause, why would he need to reach latches? I mean, if he's saying this isn't a gift clause issue, I'm not sure. But either way, you still knew that latches was something that you could raise regarding evasion.
Again, Your Honor, from our perspective, it wasn't clear after the motion to dismiss stage, but the court did exactly what you just described on the evasion clause ruling. It reached the merits of the evasion clause, and then as sort of a throwaway was like, oh, and latches also applies, even though they...
In the reverse. I mean, he found latches, and then he said even if. So
Right.
That's... Anyway, what is your headline? You know, you win, and we say there was an abuse of discretion. What's your headline as to what is your best argument about what the error of law is and your best argument about how the record lacked substantial evidence for his findings?
The best argument is that the court inverted the burden of proof, did not apply the substantial harm requirement that Arizona courts have been abundantly clear. They must come forward with a preponderance of evidence and must prove it's more likely than not that substantial harm will occur. The only evidence they've relied on is this sort of speculation of potential harm. And that's not enough. That's not enough under League of Cities and Towns v. Martin. There, the Supreme Court said, actually it addressed a very similar question, where the court declined to apply latches because of the measures that might have been taken. So it sort of looked at the speculation piece, and it said that wasn't enough. Might speculation isn't enough.
But didn't Judge Fox also deem that the $32 million that they were into it over the course of that year was also prejudice to them because they'd expended funds thinking that this was okay to do, and now they're $32 million in, and you're raising a claim? Wasn't that another part of what he was relying on?
I don't think that's sufficient. They would have to prove that they would not have otherwise had invested that money. And the record makes clear that that's very likely not the case for a couple of reasons. So the court would have had to found that that they would have stopped construction if this case would have been filed 3 months, I guess, 3 or 4 months before appellees would have preferred it, to have been filed. Here, they started construction 10 days after the development agreement was signed. Even though our clients requested public records 2 months prior, they didn't give our taxpayer clients the public records until 21 days after.
Would it have mattered if they had given them to you 2 months before when you requested them? Because your argument in regards to the statute of limitations is that the statute of limitations didn't even run until the agreement was signed. So would it have mattered if they would have given it to you earlier than that?
It would have mattered only for purposes of their argument, which we believe is not supported by the record, that, we never would have even started construction, it would have mattered on that piece. But the real problem, Your Honors, with the court's laches ruling is it essentially has usurped the authority of the legislature, which has set out a very clear 1-year statute of limitations to challenge government actions by citizens in good faith. And what would the trial court have wanted these taxpayer citizens to do? I mean, they did everything that responsible citizens are expected to do. They petitioned their government. They sent them letters. They asked for follow-up. In fact, they asked for a follow-up as late as January 2022, and the city of Phoenix said, we'll get back to you. We realize that you have concerns about the constitutionality of this arrangement. We'll get back to you, and they never did.
So, counsel, is that a critical point as to the laches timeline? I mean, arguably, if they weren't responding and they said they would respond in 2 weeks, wouldn't we look at laches from, end of January until you filed? Wouldn't that really be the time period versus the year?
It's a much better time frame, yes, Judge Patton. And critically, taxpayers were in sort of an impossible situation, and they were doing what they ought to have done, and they shouldn't now have the courthouse door closed to them for having tried to petition their government in good faith, which is precisely what the trial court ruling did. But so as late as January, they were being promised a response from the city, and then they filed 3 months later. They're like, okay, we're obviously not going to get one now, so we have no choice but to reluctantly bring suit within the statutorily authorized statute of limitations. That's appropriate.
Can you just clarify the Giplet treatment? I think you make an argument in your briefing that this suit came early in that.
Yep.
And so my understanding was that you apply for it, but not until the certificate of occupancy issues do you actually get it. Is there something in that space that you want to make more clear factually to us? Absolutely,
Your Honor. I think it's a critical fact. And if you look at Appendix 119, this talks about an indemnification provision between Garfield and the city. And what they say is, look, we're going to indemnify you for any challenge, including under the gift clause, so they clearly anticipated this. Why that's important is because that provision doesn't take effect until construction's complete. The lease doesn't become operative until the building is finished. So they anticipated litigation in their contract, and we have to take them at their word in their contract, not when construction began, but all the way up to the point when construction was complete. So it's very hard, I think, as an equitable matter, or as an equitable matter, for them to come in and argue, well, we were prejudiced, even though we anticipated this. There was unreasonable delay, even though this was filed long before we anticipated it to be filed. That's completely incongruent on this record. Another point on prejudice, too, for the court, the whole project, the whole basis of it is it was expected to increase the intervener's profit margins from 5.56% to 6.51%. That's it. That, again, also is not evidence of substantial harm under Rash and the litany of cases that describe what substantial harm is. But more to the point, the reality is they knew this arrangement was questionably lawful. They knew that because the trial court had just declared a nearly identical arrangement unconstitutional under the gift clause 4 months before they entered into this one. So they had strong suspicions as to its legality. They knew that taxpayers were concerned about it because taxpayers were petitioning their government not to do this. But instead of trying to go back to the board and decide, what can we do to make this lawful, the Garfield appellees went and pressured the city to go forward anyway and said the risk is all on us. We shouldn't let an activist court determine the policy-making prerogatives of the city. Under those facts, for them to come in and invoke an equitable doctrine does not do equity. It turns equity directly on its head.
Can I ask you a question about the evasion clause? Sorry, back to that. Did you need to challenge the constitutionality of the statute to get to the evasion clause problem that you say you have, in that isn't it always going to be the case that there's transfers or use of property that looks like it's evasive just in the statute as it is?
No, we don't think so, Your Honor. The statute can be used constitutionally in a whole variety of ways. And
only if the city owns the property already?
that's the most obvious way, and that's what the Abor case said.
So the only way that it's constitutional is if the city owns property or buys up property and then advertises for GIPLET to build and get this tax treatment.
Well, the reason that statute was put in place, Your Honor, was so that property that was already owned by the government could be leased to private parties and put to a good use, and then the city could receive excise taxes for it. So if it's used according to its intended purpose, that's constitutional. There could be other circumstances, Your Honor. I suppose if they did this and then the property was put to an actual government purpose instead of being used and operated for the sole benefit of a private party, it could still not violate the evasion clause here. The whole problem with this would be as if Garfield went to a charity and said, hey, we're going to transfer this property to you, and even though we're still going to use it as a high-rise luxury apartment building that we're going to own, control, and be able to transfer, it's charitable, even though it's not put to a charitable purpose. Obviously, that would run afoul of the evasion clause. This is, in fact, even worse, because they're saying that this is government property and municipal property. And Arizona courts have been very, very clear that municipal property is not property that's used for a private commercial interest. The courts have set that out time and again. So this has none of the characteristics at all of municipal property. That's the Yuma irrigation case and the Bowles case.
Before you sit down for your reserve time, do you want to talk to us just a little bit about the MDB and the argument about the give-get there as far as the taxes that they've said, the $9 million that they've said is the equivalent?
Your Honor, that is a total and complete mirage. What the Supreme Court said in Shires and in Token, and is abundantly clear in the gift clause case law in this state, is that a business's obligations to pay taxes never count for purposes of the give and the get under the gift clause. Of the $9 million minimum direct, quote-unquote, minimum direct benefit, $525,000 is the rent payment, so that counts. $8.5 million is taxes that Garfield already owes or would otherwise pay. $3.6 million of that is from pre-construction TPT, so that's paid before the project's even completed. $2 million is from TPT or sales tax during the lease, and then $2.9 million is property tax after the lease. So the entire minimum direct benefit is satisfied completely through the payment of taxes, which the courts have been abundantly clear does not count as consideration.
Thank you.
Thank you, Your Honor. I see I have 3 minutes left.
Good morning, Your Honors. Daniel Inglese for the City of Phoenix. I'd like to spend just a few minutes, maybe 3 minutes, discussing our cross appeal on statute of limitations grounds before handing things off to Mr. Johnson to respond to the appellant's arguments. This case is governed by a 1-year statute of limitations for claims against the government. The ordinance at issue here, and which contained all of the material terms that plaintiffs are challenging, was passed in October of 2020. But the claim was not brought until May of 2022. And the very first request for relief that plaintiffs have made in their complaint is not only to declare the ordinance unconstitutional, but to enjoin its effect. And at least that request for injunctive relief is time barred. But we think that the clock for the entire case starts running from the point that the ordinance was passed.
Aren't there so many things that can happen between when the ordinance is passed and when the agreement itself is inked? I mean, the ordinance, wasn't it just giving the city the authority to enter into an agreement and come to terms with your client about what the agreement was going to look like?
Sure, Your Honor. The ordinance does authorize staff to continue negotiating. However, the material terms can't differ from what was outlined in the ordinance and the accompanying council report, and that council report is at Index of Record 18. It's Exhibit 1 to the request for judicial notice. Those two documents outline all of the material terms. There's, as far as the gift clause is concerned, it's all about give and get, and in the intervening time, staff can't do anything to adjust the give and get. Only council can make financial decisions. And so plaintiffs had all of the information that they needed to challenge the ordinance. And again, the proof is in the way they pled their complaint, which is that the very first request for relief they make doesn't relate to the contract, which is when they claim that the statute of limitations accrued, but relates to the ordinance, which they clearly believe.
Wasn't the ordinance an authorization? I mean, it was a may. It was that staff can enter into this, the city can enter into this agreement. Not that they have to, not that they have, it's a may. Isn't that correct?
Your Honor, yes, it is an authorization for...
If that's the case, if it is an authorization, then there is no contract until something actually gets signed. Isn't that correct?
That's correct, but there still would have been a ripe gift clause claim at that point because plaintiffs already knew all of the material terms. They could have run to the courthouse.
I think the case law on gift clause says that there has to be something that's given. And at that point, there wasn't anything given. It was just an authorization that something be given. Isn't that correct?
Understood, Your Honor, and yes, at that point, the city had made no binding commitments. However, again, plaintiffs' own complaint belies the idea that the ordinance didn't start the clock ticking because they have requested relief that runs from the time that the ordinance was passed. To adopt plaintiff's theory of the statute of limitations in this case would essentially say that government contracts and government actions have two accrual dates, and we think it's at least worthwhile for municipalities to have the certainty about when exactly they should start looking over their shoulders and worrying about a gift clause claim. We think that the Superior Court erred on the statute of limitations argument. If there are any further questions from the panel on the statute of limitations question, I'm happy to take them. Otherwise, I would love to give Mr. Johnson as much time as possible. Thank you.
Good morning, Your Honors. May it please the Court. My name is Brett Johnson on behalf of Six and Garfield Owner LLC. It appears that appellants believe that G-plets are somehow unconstitutional, and yet they don't actually challenge the constitutionality of the statutes at issue. Instead, they decided to wait until someone enters a transaction, starts building, and then pounces after substantial progress has already been made. In regard to your last question, Judge Foster, I would direct your attention to the relief. The request is in regard to the ordinance that the appellants are actually challenging, and the ordinance obviously was issued long before. But staying off statute of limitations, I would at least want to address latches for the first part because that was the majority of the conversation with Mr. Riches. He brought up an argument of a de novo review. From our perspective, and we obviously cited the McLaughlin case, it's an abuse of discretion, and it has to be devoid of any competent evidence. Judge Fox used the correct legal standard, and the factual determination was definitely not abuse of discretion because it was not devoid of any competent evidence. And in fact, Judge Fox...
Did the court clearly err when it did not give any credence to the fact that taxpayers had issued letters, multiple letters, to which the city and Garfield had not responded to?
Your Honor, I don't think that the judge erred because the judge actually, if the judge did not make reference to those letters at all and just ignore that those letters occurred, then there might be an issue. But Judge Fox, in his decision, actually went through the letters and the importance of the letters. That's why that he evaluated the competency of the evidence and found that the appellants had not met their burden to show that latches should not occur. But in regard to the latches, we have to look at McComb. McComb is right on point. It's not just a letter writing campaign, and we cited several cases to that effect. You have to actively be doing something. If there were actual negotiations that were in place, then maybe a latch...
They were trying to negotiate, and nobody responded, and they kept putting them off and putting them off. Give me a couple weeks, month one, give me a couple weeks, month two, give me a couple weeks in January. So I don't think that that's dispositive in and of itself, but when you say they weren't trying to negotiate, you could read that a different way.
Your Honor, I appreciate that, but let's look at the actual letters. The letters were demands. It was, this violates the gift clause, and you need to stop the transaction. That, there was no, let's have a meeting and sit down and negotiate about it. That's not what those letters were for. It was, tell us what your response is going to be, and that
The
was...
city didn't.
I'm sorry?
They didn't tell them a response. The city drug them on over and over, and they kept waiting for a response. The city said that they were going to get them a response, and they didn't. So what is a taxpayer to do who has an issue with their government? They're trying to resolve it, get a response from the government, and I forget what case it is, but there was a case where, and it wasn't Macomb, it wasn't McLaughlin, where it might have been Western Sun, where, you know, the action was taken and there was a repudiation. And here, we don't have a repudiation from the city. If there was a repudiation and taxpayers had sat on that, I could understand your point. But there was no repudiation from the state or from the city.
Your Honor, in regard to the first letter, there was a repudiation, and then there was a second letter several months later on top of that. So there was a clear repudiation showing that
That's before the agreement, though?
that was before the agreement was signed,
Okay.
but it was after the
Post-ordinance, pre-agreement.
post-ordinance, pre-agreement for sure, Your Honor. But in that context, when you have your complaint basically written in a letter, you then wait a year and wait for the construction to actually begin, and that's the reasonableness of the conduct here. Was it reasonable? You have a draft letter that is easily convertible into a very simple complaint. They had just gotten off of the Derby-Engelhorn case, so they were well aware of the position of the city from that perspective. It wasn't like there needed to be a
If
year.
you're crediting for that, I want to just shift a little bit to say 30,000-foot view. Are we looking at latches as an operative set of facts, as I asked appellant, or claim by claim? Because you just say, well, we all just went through this litigation and they should have known, but doesn't that weigh against you on the evasion claim that you should have known? I mean, you're saying latches on the evasion claim, and Judge Fox seems to, I think maybe what Judge Payton was getting at was that Judge Fox seemed to discount or not even consider that letter writing, however you want to frame it, whether it was enough notice, not enough notice, but didn't consider the letter writing because he said the letter writing did not raise evasion claim, and that somehow so basically it's like you woke up and all of a sudden you saw you were going to be sued on the evasion claim with no notice whatsoever. And you're saying, well, we all just went through this together and we knew what the claims were going to be. So doesn't that kind of cut against your client being surprised or prejudiced by an evasion clause claim being raised when they did file suit?
Your Honor, I'm going to answer your question two ways.
Yeah.
First of all, I do think it's operative facts. The facts are the facts, and they're going to apply. They're both constitutionality claims. I appreciate they're not challenging the statutes, but they are challenging the transaction.
So if we find no latches, both claims are resurrected. I understand he made a substantive ruling on
Gift clause.
evasion, so that's a little bit different. But they both rise and fall together.
Well, there's a lot of other issues with the gift clause analysis too, but Your Honor, in regard to that they rise or fall together, if the operative facts are the operative facts. But in regard to that, let me couch that. I do think that it's an operative facts, but the way that Judge Fox did in regard to the tax evasion and that those weren't in the letters, talking about consideration of the letters, although I believe that they are operative facts that apply to both clauses, if the court was to consider that they should be somehow bifurcated in that for the motion for summary judgment, those should be, then I guess it would be a case by case.
Is that your error? If both of you have said with no question that the latches analysis is the same because it's operative set of facts and there's no dispute that it was the Giplet tax treatment that was the underlying transaction, then is that what Judge Fox did wrong, and that he only looked at your notice as to evasion claim and did not consider that you guys had been back and forth with each other for the preceding almost 2 years?
No,
he didn't.
He didn't. You're absolutely right, Your Honor, because the gift clause was dismissed by that point. So you only had the tax evasion claim to actually go.
He's saying that the notice that you got that there was a claim against the operative set of facts that we've now agreed is the basis of the claim, if he's not considering what the interaction was on the operative set of facts the whole time, is that error?
It's not error, Your Honor, because then what I perceive you're asking, Your Honor, is you're talking about the substance, whether or not it was gift clause or tax evasion inside the letters. I think that the more operative concept here is to actually get into the reasonableness, right? So you do have the tax evasion claim that came from Engelhorn, and then but was also raising a gift clause in that case. The city was well aware of it. The developer was well aware of it. Okay, so we're all well aware of it, and everybody probably expected a lawsuit right after. Definitely the development agreement was provided in June, and then the construction had already started by that point in time. Any reasonable person would have expected a lawsuit. Waiting a year and $32 million later, that is where it's unreasonable from the purposes of McComb and McLaughlin and the other cases. Then you get into the actual prejudice, and again, Judge Fox gave credence to the $32 million. It's not just the $32 million. It's also the actions that were taken over that year period that could not have been modified by a lawsuit if a judge would have gotten involved in June. So those are some of the issues that really have to be, you have to look at the timing as well as the prejudice underneath the Latches argument, not just what was known, because we did know that the appellant knew about the tax evasion and did know about the gift clause, although in their letter, they only raised the gift clause issue.
Well, speaking of prejudice, how do we treat the fact, so you talk about how based on Engelhorn, the parties were there's probably going to be a lawsuit. When we look at prejudice, how do we treat the fact that the city and Garfield were on notice that there could be a lawsuit because Garfield agreed to indemnify the city for the Giplet litigation risk?
Well, Your Honor, I think that the parties are able to rely on two things. The statute of limitations, which from the ordinance standpoint, the year period was up. In addition, they are able to rely on the doctrine of latches. That is good law. And if you know you have a claim, you've drafted two letters to that extent, and then you don't bring action until a year later after construction has already begun, that is the epitome of why we have latches, which is the equitable basis. And then on some of the arguments in regard to prejudice, I want to make sure I address that from what Mr. Rich has talked about. In regard to discovery in 30B6, well, they filed their motion for summary judgment first. They believed that they had enough facts. Secondarily, Your Honor, in regard to our motion for summary judgment, they never raised Rule 56D. If they needed more facts as to prejudice or reasonableness of time, then they should have addressed that with Judge Fox, and they did not. They were all ready to go on the record that is presented. In addition, Mr. Rich has made reference that somehow the economics was speculative. Obviously, again, that was not raised below, so it's waived here. There was no argument about speculation. And then, obviously, latches is a separate doctrine, as I mentioned before, in regard to the statute of limitation. The harm is the delay. That is the harm here. But let's say that for some reason, even if it was not waived and
The prejudice is the delay? What do you mean?
No, I'm sorry, the time. The delay is the prejudice, Your Honor. I might have said that incorrectly.
The delay is the prejudice.
The delay in bringing the case and the ramifications of that delay, yes, Your Honor.
And the ramifications of that delay, though, how are they quantified? I mean, the Fox says it's the $32 million that you spent from agreement signing in May until suit initiation the next May, and credits you with that whole $32 million that Garfield spent. And you're saying it's the time, it's not the money?
No, it's time. That $32 million is spread. No, I understand, Your Honor. $32 million is spread over a year period of time. Right. If you would have done month before would have had a much smaller amount, right? So basically, if there was an action brought right after the development agreement and there was a more de minimis and he has the emails, hey, we're bearing the risk on this, then obviously latches is probably not going to be the argument, and maybe it's just the statute of limitations. But under the record that is presented here, it definitely was not an abuse of discretion by Judge Fox. to make a determination that latches applied. Factually, he applied the correct standard, and it was just not an abuse of discretion in regard to that. And as the trier of fact is the better weigher of evidence, this court should give credence to that. But
Mr. Johnson, I want
Yes, Your
to
Honor.
go a little bit to the prejudice and the $32 million, because that number has been thrown out as, this is the potential harm that $32 million has been spent. But was Garfield even expecting to make $32 million off of this contract? I mean, my understanding is that the maximum direct benefit was $9 million. So can you even argue that it's $32 million that you're harmed?
it is $32 million because, let's actually back up if you don't mind, Your Honor. So this wasn't my client's idea to come to the city and say, hey, I want to build this building in a slum area and you give me a GPLIT. The city put out an RFP on it. Our client bid on it. It went through meeting after meeting, and then obviously my client was awarded the development agreement for purposes of this contract. So as part of that RFP process, my client is going through an extreme amount of money to not only prepare for the proposal, but then during that year period putting in their portion of what they've promised to the city to do, which is to build the high-rise. Over a year period, that is $32 million. If appellants would have challenged the ordinance or earlier challenged the development agreement, then there would have been an opportunity to renegotiate, as Judge Fox made reference to. But one thing for sure is the $32 million and all of the acts that underlie those $32 million could have been viewed in a different lens. Our client would have been in a position to be able to possibly back out of the deal. It could have done a lot of other things, as Judge Fox made reference to.
Possibly being able to pull out of a deal, isn't that speculative? And how, I mean, there's no record below about the fact that you were on record saying that your client was going to make a 5-point-something profit on this, and that the tax treatment was going to change it to somewhere over 6%. So was there any evidence below that not having a fully operational luxury building in what your own report said was like the up-and-coming area, that there was a 10-year, this place was going to boom, and you're going to be right in the middle of it? So was there record evidence to show that your client wouldn't have gone ahead with it anyway?
Yes, Your Honor. I point you to John McClendon's declaration at IR 77, paragraph 15, which made specifically in that regard. And, Your Honor, you're hitting on a point, which is, hey, this area was up and booming. That goes to the root of the appellant's problem here, is that they're not challenging, one, the constitutionality of the statutes underlying, and it's not just the, I apologize, it's not just the Title 42, but it's also the Title 36-1472, 36-1474, which is about the slum. So if they do not believe that this was going to be a slum in the near future, they could have challenged the city's determination underneath the Slum Act, I can't remember the exact title, that the city made this and declared this underneath Arizona law. So
But I don't like this should have, because I could say the same thing back to you and say, shouldn't you guys have taken a deck out? You just went through the Superior Court saying that this was unconstitutional to give this tax treatment. You could have gone to them and say, we want you to rule that the way we've changed this now, we can go forward with.
Yeah.
I mean, what litigation could have happened, I think gets us way too far afield. What litigation did happen is what I feel like we have to focus on in the decision.
Your Honor, I respect that. And the one point in particular here is that there is no law that forces a party to do a deck action just because they're threatened. If that was the case, every time Mr. Riches writes a letter to the city or writes a letter to the state would have to run to court to get a deck action when Mr. Riches may not have even actually planned on challenging that. So there's no onus on the city or the developer or whoever is entering business with the government to first run to court to make sure that it's okay. So from that perspective, what we can rely on is the statute of limitations. Council's already addressed that, and definitely latches. And for this record, I apologize it's out of time, but for this record,
You can have a couple more minutes.
yeah, for this record, Your Honor, it was, it definitely was clear. The one last thing, Your Honor, on, I just real quick, I apologize. The the direct benefit versus the minimum benefit, obviously, Judge Fox never got to that point, right? Because he determined that the GPLIT it's a classification issue. It's not an abatement from the ad valorem taxes, it's a classification. And again, if they have a problem with the classification, they should have said, the appellant should have raised that this was an improper classification as a GPLIT and it should have remained as an ad valorem, and they did not do so. With that, I'll rest.
Mr.
Oh, yes,
I
Your
just
Honor.
have one more question. You mentioned the McLaughlin case and the McComb case in terms of the latches issue. Those cases were very different. They involved, sort of election issues that were very timely, the seating of elected board members. Do you have any cases that are more related to construction issues that address latches?
Yes, Your Honor. I don't have the page of our brief, but there's not an Arizona case necessarily on point, but there were about 5 or 6 out-of-state cases that talked about you cannot wait until the drills hit the ground until you bring a lawsuit. I believe it's an Illinois case, but don't hold me to that.
That's okay.
Okay.
Thank you.
All right, thanks so much.
All right, thank you.
Can you just add a minute, just so he can keep track of his time? Thanks.
Thank you, Your Honor. To address your last question, Judge Foster, League of Cities and Towns in Martin and Unkenfer are the ones that control. League of Cities and Towns says you can't establish a laches defense based on speculation. And Unkenfer says that a party claiming laches must do more than just claim some harm. That's all we have here. That's the only record we have here. And what's so dangerous from the appellate perspective, from their argument, is that if they essentially try to invert and put on plaintiffs the burden, when laches is an affirmative defense that they must come forward with. I think this would be a different case if there was a record that said, oh, we absolutely would have stopped construction, we would have made these changes, we would have changed position. There is zero evidence on that. And they have to prove it's more likely than not. And that's just an evidentiary failure that simply is just abundantly established
So
by
that's
this
your argument
record.
about how we deal with the 32 million, is it doesn't matter if it was 1 million or 100 million, if it wasn't going to change their position, then it's not evidence of latches.
That's correct, Your Honor. In fact, what the record does show, and obviously it's not these same parties, but there was 2 other circumstances, and this was clear in the record, where the City of Phoenix offered the developer, in one case of a 19-story high-rise luxury apartment building, identical to this one, a GPLIT, and then the city was enjoined from providing it in the Engelhorn case. And in the records case, they pulled it back because there had been some damage to a historical building and they didn't want to give a GPLIT anymore. In both of those cases, in the same exact area for very similar projects, in one case a nearly identical project, the projects went forward anyway. Now, I realize those are different parties, but what this record does show with respect to these parties is they were always going to go forward with this arrangement regardless of when or whether a lawsuit was filed. We know that from the communications between their lawyer and their city. We know that the way they treated and essentially just disregarded the Engelhorn ruling. We know that they were ignoring taxpayer communications and they intended to go forward with it anyway. And on those facts, laches simply cannot apply. To this issue about the ordinance having been passed, and that's the point of accrual, it is abundantly clear that the passage of an ordinance is never the cause for accrual, right? Any constitutional case where a statute or an ordinance is passed is not challenged until it's enforced. And in a gift clause, Loving v. Virginia, the statute was passed 40 years before the constitutional claim was brought. And in a gift clause case...
Challenging, though, the statute, not the transaction.
Sure, but in a gift, well, I think it's even more important, Your Honor, in a gift clause case, because there has to actually be an agreement, and as Judge Foster observed, there was no agreement. Both parties could have backed out at any point after the passage of the ordinance. But 2, the give and the get are critical. You have to look specifically at the facts and what's being provided, and those facts were subject to change all the way up until the agreement was signed, as the letter of intent makes abundantly clear. The letter of intent between these parties said that this is not binding, the parties can back out, it confers no legal rights or obligations. That's simply not enough. Had taxpayers rushed to court, it would not have been right, it would not have been ethical for taxpayers to have gone to court if there was no binding obligation to challenge.
Counsel, when the city and Garfield weren't responding to your letters, why didn't you just file suit then?
We wanted to give, one, we needed the agreement, but we wanted to give them an opportunity to change position and make the arrangement constitutional. They knew.
Did you make that record below?
Um,
Did anyone ever ask you, is it in the record anywhere, that you told Judge Fox that your reason for not filing suit?
That was in the letters that taxpayers sent to the city, which outlined our legal concerns with the arrangement.
Did you ever tell Judge Fox in the record, did he ever ask, or was it ever raised, why you didn't file suit?
The only piece that was raised was because we were waiting for a response from the city that never came. So that was the why, if I understand your question correctly, Your Honor.
Okay, all right, well, thank you all for your arguments. We will take this under advisement and issue decision in due course. We're adjourned.